Welcome back, welcome back. We were facing some technical technical difficulties with the audio, and now we are back. So thank. Mm. So welcome back to the Intellectual Property and Trade Nexus podcast. We are glad to have you following us. Sorry for the technical glitches we were facing with the audio quality. Now we are back. The audio is clear, the visual is clear, so we cannot move. We can now move into today's episode. Today we will be discussing intellectual property, competition, and antitrust laws and protection. So we want to look at the interface between intellectual property rights protection, competition laws, antitrust laws, and policy. How does competition laws and antitrust laws help or assist IP rights holder to protect their rights and to give them the competitive advantage in any trading market? So we'll be looking at IP competition, antitrust protection. But before delving into the issues and discussing what it requires, what are the benefits of having competition laws, what are the benefits of uh, having antitrust laws, we want to understand what is competition and what is antitrust. We might have those of you that have been following this podcast, general overview or a general understanding of what intellectual property is, because this is our key topic here, intellectual property and international trade. This is the forum for innovations in trade. This is the forum where intellectual property links or connects with international trade regulations. So you might have an understanding of intellectual property protection. How do we protect innovations? How do we protect the creative minds, those that have the capacity, the ability to produce tangible as well as intangible assets, the creation of the mind, being an inventor, being a creator. Uh, we discuss all issues related to intellectual property rights holder. It could be patent protection, copyright protection, trademarks protection, trade secrets, and today we will be discussing the interface between the interface between intellectual property, competition, and antitrust laws and protection. So before moving into the issues, we will want to give a denotative uh, definition of what a competition law is and what antitrust is. So if this is your first time coming in connection with this topic that has to do with intellectual property protection and how competition and antitrust law can better serve as a competitive advantage to uh, IP rights holders. So from a denotative understanding, we want to give a basic understanding of what competition law is and what antitrust law are. So we say competition law is a body of legislation that is intended to prevent market distortion and caused by anti-competitive practices on the part of businesses. So simply put, competition law is a body of legislation, a body of laws that are intended to prevent what? Market distortion caused by what? Anti-competitive practices on the part of what? Businesses within that market. So this is this is a brief definition of what competition is. And competition law is also practiced mainly in the United States, in Canada, the European Union, and is also considered in those regions or in those countries as antitrust. Is also known as antitrust law. So competition law is a body of legislation or of laws that that is intended to prevent the distortion caused by what? Anti-competitive practices by businesses. So in terms of anti-competitive practices that give other businesses the edge in terms of pricing, in terms of price fixing, in terms of price gouging, in terms of having a market power in a specific market uh, because they are the monopoly that produce a specific goods. Take for example, if a company was or is the sole importer of rice or the sole importer of petroleum in a given market, that company automatically becomes a monopoly. And monopolies have the tendency to ensure that they support the implementation of anti-competitive practices within a given market. Because if anti-competitive practices are implemented or carried on by those businesses, they stand at an advantage to benefit from the market. And consumers in this case will then become the victims of anti-competitive practices executed by monopolies. So competition law has to do with a body of laws that is intended to prevent those anti-competitive practices that businesses carry on in the interest of gaining profit, increasing the profit margin, increasing the market power on specific goods, products, or services that they provide within that country or that territorial confinement. So this is what competition law is. Competition law is basically in general intended to fight anti-competitive practices that are against consumers, anti-competitive practices that that do not encourage fair competition within a given market. So this is it. This is what competition law is. A body of legislation. Competition law is a body of legislation intended to prevent market distortion that is caused by what anti-competitive practices by what businesses within a given market. So in the United States, in Canada, and the European Union, competition law is also known as antitrust law within these given localities. But competition law and antitrust law have some variance. They may differ in certain cases and instances, but we will go into that as we discuss antitrust law. So the basic purpose of competition law is to ensure fair fairness on the market, uh, both for consumers and for producers, and to ensure that unethical practices are prohibited. Competition law is basically to ensure fair market practices that benefits both consumers and producers and prohibits unethical practices designed to garner greater market share. Greater market share in a sense that if the market was a competitive space that businesses within that market are competing, and every business or company within that market have a fair chance of competition. So in that case, it will be somehow difficult but not impossible to have a greater market share. So uh, unethical business practices that companies or business might use to gain a higher market share or uh, ensure that they engage in maybe profiteering. So competition law wants to address that challenge and ensure that the market is a fair playing field on the market, that unethical practices are not encouraged. Unethical practices have consequences if you are a business and you engage in profiteering at the detriment of the consuming public or the end user of whatsoever commodities, products, or services that you are providing on a market. Unfair competition law ensures that violators of the laws or those engaged in unethical and anti-competitive practices are penalized. And it encourages a fair playing field for all businesses to compete fairly. So competing fairly on the market will result to not only difficulty for so competing fairly on the market will result to small businesses having the possibility of engaging in fair business practices and have a chance to grow, to make the necessary adjustment, engage in the necessary marketing strategy, the efficiency and effectiveness or productivity of whatsoever goods and services they are providing. They can be able to compete for a specific a niche on the market, and in return, consumers then can be the beneficiaries, because if you have more businesses within a specific market providing services, or if you have 3 to 5 person 5 companies within the hairphone business, or 10 to 20 companies in telecommunications, and the market is open, is very competitive. Consumers and end users tend to benefit and to enjoy from the competition that is going out within the market. However, when anti-competitive practices are done within a given market, the effects are that it's difficult for small companies to enter the market or succeed in the market, because you have bigger companies that are competing, and all of those bigger companies are engaged in unethical business practices or anti-competitive practices. It makes it very difficult for startups and smaller and medium enterprises to jump, to enter into the market, and the sustainability of those startups and small and medium enterprises within a given market will be quite a challenge. The success of those companies will be kind of difficult, because the bigger companies are not playing fair. They are not playing by fair rules that can serve as an advantage to the smaller companies. So there are drawbacks from having anti-competitive practices within a given market. And more importantly, the consumer within that market will tend to pay higher prices. The consumer will not benefit, because there is no competition, and the consumer will be in a position that prices within that market will be very high, and exorbitant prices on goods, and the services that will be provided will be poor, and there will be less innovation, because if you have two or three companies determining the prices of headphones, or two or three companies within a given country that is in the telecommunication space, or maybe one company within a country that is importing, for example, rice, that company can make a determination on the price of that goods of rice within that market. And the services that they provide will not be quite effective. The service will be very poor, because there are not many alternatives for consumers or end users to go to. There are not many options for consumers to get that specific goods or service from. So innovation would be very poor, and the productivity of those companies, maybe one or two monopolies within us in that given market, will be very low, poor service, higher prices, low innovations, because there's a lack of competition on the market. So this is what happens when you have the lack of competition, or the lack of effective and efficient competition law on the book. You can have a very fine, a policy driven, all the policies, the laws and regulations on the book. If you are not implementing them, the consumers will not benefit from a very competitive space. Um, Good prices on the market, a very innovative space, and the services that is being provided will be very will meet the consumer needs, because there's a lot of competition, and no company or business want to lose customers. So it will be in the 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 in a market where competition is thriving, consumers tend to be the beneficiaries. In a market where anti-competitive practices and unethical business practices is, is the rule of the day, consumers tend to be victims of that market. So this is what competition law does for consumers. It's basically in the interest of consumers. It has some benefits of consumers protection attached to it. So what are, when we say anti-competitive practices, when we say unethical business practices, what it entails, what does that mean in plain terms? So we're talking about pre predatory pricing that is predatory in nature, which involves monopoly, oligopoly, charging an exorbitant price. Like I've stated, the prices on the market will be very high and exorbitant in nature, that consumer will not be able to afford their goods, or they will have no alternatives or options on the market. They either purchase from that identical company, or if there are two companies with higher prices, they have no other options but to purchase the goods. So the prices are predatory in nature, they are very exorbitant, and consumers have little choice other than uh, to purchase the goods because they need it. And the issue of price fixing, the issue of price fixing is a particle sense of anti-competitive practices. So price fixing may involve the collusion of companies to make a determination. Say maybe we have two companies importing gasoline within a specific nation, and these two companies can collude and make a determination on a fixed price that the consumers will pay. And this price will be very high and exorbitant. But in a very competitive space, you might have more than one importer of petroleum product on the market, maybe 5, maybe 10, maybe 15 importers of petroleum, and there's no collusion where those companies will go to a meeting, maybe and make a determination on what price could be, because there are many in a field, and so they need to compete. They need to provide the services that they require. They need to provide a price that is affordable for consumers, and they need to be innovative enough to reach consumers to provide the necessary services that is required. So these are the anti-competitive prices. uh, Meeting, colluding with other businesses or companies to have a fixed price, uh, so that you and your competitor can benefit from the spores of anti-competitive practices. So that is what competition law in a nutshell is. Competition law is a body of legislation intended to prevent market distortion caused by anti-competitive practices on the part of businesses. In the United States, in Canada, and the European Union, competition law is also known as antitrust law. So we have basically dealt with competition law. Now let's look at antitrust law. What is the denotative meaning of antitrust law? So antitrust laws are also body of regulations or laws that encourage competitive practices, or that encourage competition by limiting market power of any particular firm. So antitrust laws and regulation encourages competition by limiting the market power of any particular firm. And it often involves ensuring a merger and acquisition done overly concentrate on market power or form monopolies, as well as breaking up firms that have become monopolies. So this is what antitrust law is. Antitrust laws and regulations are meant to encourage competition. Competition law is meant to ensure that there are body of laws meant to ensure that it addresses the issue of anti-competitive practices and unethical business practices within a given market. Antitrust law, on the other hand, are laws and regulation that encourage competition by limiting market power of any particular firm. And it often involves what? The It often involves ensuring that merger and acquisition, companies are merging, another company acquiring or buying another company, mergers, two companies that have some monopolistic characteristic. They are giants within the market and they are merging to ensure that the competitive advantage is much stronger, is more strengthened to the extent that they have a greater market share and they can make a determination on the pricing within that given market. Take for example a company that imports maybe produce or import drugs on the market. We have two big companies and we have maybe five smaller companies. And the two bigger companies that have the maybe 80% of the market share, they are trying to merge, they are trying to come together, or they and that is merger. Both companies that have greater market share are merging to increase the market share and to increase the power to make a determination on the price of that market. Another way could be acquisition. Acquisition in the sense that uh, a bigger company within the market that have higher market share but trying to buy other companies within that market, maybe two or three companies trying to acquire or buy two or three little companies within that market to increase its market share. So that is acquisition. So in both in mergers and acquisitions, antitrust is meant to ensure that these mergers and acquisition are placed under the microscope uh, to check against any anti-competitive practice or any unethical business practice, so that the consumers or the general consuming public do not fall victim to price fixing, to poor customer service, uh, to lack of innovation within a given market. So antitrust laws and regulations are meant to encourage competition by limiting market power of a particular firm. And in most cases, these firms have monopolistic characteristic. They have they might have greater market share. They might have a determination on the price within that market. And so because of this, they can influence the market to a higher degree. So antitrust laws and competition laws are meant to counterbalance the power of bigger firms, uh, to counterbalance the market power of bigger companies or multinationals companies within or companies not particularly multinationals company, but companies that have monopolistic characteristic. They have higher market share, they have higher market power, they have the ability to determine the price of a specific goods, be it rice, be it petroleum on a given market. Very essential and critical goods are, it could be petroleum, it could be rice, like I said, for the case of Liberia, it could be grains for the case of Ukraine and other European countries. It could be medical drugs, um, medical equipments. Uh, it could be any essential commodity on a for the given market. So these are uh, the purpose of what competition and antitrust laws are meant for. The both laws, both competition and antitrust, are meant to counterbalance the market power of uh, uh, the market power of companies, of businesses that are engaged in a particular market. And it also ensures antitrust law also ensures that it prevents or prohibits multiple firms from colluding and forming a cartel to limit competition and then through price fixing. So in a similar case with competition law, uh, discouraging the collusion of companies from price fixing, from uh, collude, colluding to make a determination on the price on a given market for specific goods or service. In the same vein, antitrust law also prevents multiple firms from colluding to form what cartels. Cartels that limit competition through practices such as price fixing. So, due to the complexity of deciding what practices might limit competition, antitrust laws have antitrust law and competition law has become very distinct legal field for specialization. Excuse me. So, based on competitive based on the competitive nature of trade within specific countries, particularly global trade, because domestic trade, the impact might be restricted to a specific country, a specific domestic market, but regionally and internationally, the global market having companies engaged in anti-competitive practices is counterproductive to the global consuming public. So this will require that competition laws are, are up to present. They are aligned with the current dispensation of issues, uh, specifically anti-competitive behavior that is being practiced on the global market, and how competition law and antitrust law can address those issues, and how consumers then can stand to benefit uh, in terms of the the performance of the products, the quality of the products, uh, the the customer service that is provided in the distribution in the market as a whole, and the level of innovation that is generated through competitive means. So these are the basics. These are the basics. Antitrust laws, uh, competition laws are meant to counterbalance the market power of companies that are engaged in anti-competitive behavior. So with this, we then move to a specific understanding of how competition and antitrust protection are delivered across countries. countries might have different approach because the protection of intellectual property protection and enforcement is territorial. So there might be domestic laws to ensure uh, domestic laws for competition and antitrust laws, but they are enforced domestically or maybe regionally if you are part of a regional body, uh, or internationally if you are part of the World Trade Organization or the World Intellectual Property Organization, UNTAC, and other international organizations engaged in competition and antitrust protection. So back in the 1900s, the concept of intellectual property holds that if you are a patent holder, if you are a patent holder, you are a you are a monopolist. So that was the old concept that if you hold a patent, if you hold right to a patent, that you are a monopolist. In the 1900, going up to the late 2006. So specifically in the Americas, because America is considered the mother of antitrust law. This is where antitrust begin in the United States. So anyone holding intellectual property rights, be a patent, uh, if you held, if you was a, if you were a patent holder in that 1900 to 2006, you were considered to be monopolistic. And this is hinged on because this is hinged on the exclusivity that is attached to IP right holder. And then like I said, the United States considered the model of antitrust law. So these consideration of IP rights holder being monopolistic was specifically prevalent in the United States up to 2008 when they changed their approach that if you are intellectual property holder, you was always labeled as a monopolist. But since 2006, America adopted a different approach that it doesn't necessarily mean because you hold a patent right or any intellectual property right, then you are, it doesn't necessarily mean you are monopolistic. Due to it, it doesn't necessarily mean you are monopolistic due to the exclusivity that IP right holder carries. Because if you are a patent holder and you hold right to a patent, you can exclusively control the rights to that patent. You can make a determination on who can use it. You can through licensing, who can sell it. Uh, you know, you have an exclusive right for a given period to make a determination on how that patent is exploited. So that label is something that is being uh, the international organization, specifically the WIPO, the World Intellectual Property Organization, is fighting against now that not because an individual or company holds right to a patent, it, that automatically means that that company or individual is a monopolist. So this notion and perception concerning IP right holder being associated to monopolist is what WIPO, the WTO, and other organizations engaged in uh, competition, antitrust, and IP right protection are striving to address. So, like I said, in 2006, the US Supreme Court made a decision that IP right holder is not necessarily a monopolist. There are so many, and this can be justified because there are so many markets where there are many patents. So it's not because you have patent to maybe a camera on a smartphone, or you have patent to the microphone, you have patent to the screen, then you automatically becomes a monopolist within that market. So, for example, like I said, the smartphone market, where you need to have patent to be engaged in that market. However, the smartphone market is a very competitive market. It's not like a niche market. It's very competitive. There are a lot of patent holders. There are a lot of smartphone makers within that industry. So it doesn't automatically means that because someone holds a patent within the smartphone industry, that person is a monopolist. A smartphone industry or market is a very competitive market, and it's one of the market that is very key in innovation. Every year there are new innovations in the smartphone markets. Take for example, in Apple, there are new versions of Apple each year. The latest version is the iPhone 15. And so every year there's an upgrade, and this is also similar to that of Samsung and other key companies within the smartphone industry. There is a very competitive space. There are thousands of smartphones producers, and there are thousands of patent holders within the smartphone market. And all these patent holders cannot you cannot necessarily see they are monopolist because of the competitive nature of said market. And one thing to be also aware of is the fact that because the a given market is that competitive in nature, there, there are always startups, always new startups entering the market to exploit a different anchor of a different anchor of innovation, a different anchor of addressing some challenges within that identical market. So exclusivity by itself doesn't mean there's no competition. No, exclusivity can exist and competition in the same vein can exist. And the smartphone market is a typical example of a competitive market where patent holders that hold exclusive right to the patents are competing within that market. So it can be justified why the U.S. Supreme Court made a decision that uh, IP right holders are not uh, necessarily monopolistic. So antitrust, on the other hand, deals with, like we have discussed, a dominance of cartel, mergers, and acquisition reviews. Antitrust is specifically deals with uh, dominance, companies that have or businesses that have market dominance. They dominate a specific niche or a specific aspect of the market. Maybe a company that have the higher market share of petroleum within a given country, or company that have the highest market share for rice within a given country, or company that has the higher market power and market share of grains, uh, of medical supplies. So, so antitrust is there to ensure that it curtails these companies' power to exploit the market through an anti-competitive practices. So the antitrust law within a given country can ensure that when merger and acquisitions are done, the government is in a position to checkmate, to make all the necessary investigation into what could be the outcome if these companies that have higher market share merge, or if or another company that has higher market share and acquiring or buying a little company will increase its market share to be a monopoly on our market. So it is the government responsibility to ensure that they do all the check and verification that is required for mergers and acquisition, and to ensure that there are no that companies cannot dominate a given market and transition into cartels. The dominance power cannot be used to transition into cartels, where then they can uh, make a determination on the price consumers will pay for a given goods, service, or product. So antitrust laws, regulations, and policies are meant to counterbalance, to fight against uh, 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 the dominance of cartels, and to check all the necessary requirements for mergers and acquisition, and execute the necessary macroscopic review of mergers and acquisition. Unfair competition is about what? Misleading advertising, deception, theft of trademark by changing a few elements of a goods or service to confuse the consumers and end users. So antitrust deals with the dominance of cartels. It deals with ensuring the proper macroscopic checks are done for mergers and acquisitions. The necessary reviews are executed to ensure that unfair and anti-competitive practices are not carried out by businesses. On the other hand, unfair competition deals with what? Misleading advertisements. So let us address a misleading advertisement first. So you advertise, okay, uh, maybe a little practical. So you advertise this product is a jar of water. This is what I normally use. Let me get taking small water somewhere. Okay, on my illustration. So you are advertising this as a product, but then while advertising, you are telling consumers, you are advertising to consumers and misleading them on the capacity of this uh, 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 bottle, on how many, the amount of millimeters of water it takes in. We have here 950 millimeters of water, and maybe you say 2000 millimeters of water is misleading because the actual amount of water that is a bottle is able to take is, you might not be able to see the amount, but it's 950 millimeters. And you went through the advertisement, you said 2000 millimeters. That is the first misleading information. And the second thing, again, maybe another type of misleading information is that you said that this bottle is capable of making, if you place water within this bottle within maybe 5 to 10 minutes, is capable of turning the water into a colorful water of a colorful water that is blue. So because a bottle color is blue, you advertise that if you place water into this bottle, it would in 5 to 10 minutes, all the water will turn blue. So the measurement is misleading. The capacity of the bottle in terms of the water it can carry is misleading. You are also misleading the public that the bottle is capable of changing whatsoever water that's placed in it to turn to blue, the color of blue. So this is misleading advertisement. It could also be used for the hairphone. This hairphone has it uses Bluetooth. It has we have here this mic off, and it has the volume at the back. So if you give more, maybe the function of the headphone are very specific and maybe you overstated the function, you made statements that are not factual in nature just to advertise and to ensure that consumers buy your headphone. So it's what we refer to as misleading advertisement, uh, giving false information, maybe for a product or service that is not truthful in nature, but because you want for the consumers to buy that product or to use that service, you are misleading them through advertisement. So misleading advertisement. Then we have deception. Deception could be what I could consider if deception. Okay, let me come to this iPhone. So deception. This is iPhone 13 Pro Max. So a deception could be that someone is interested in buying this phone and maybe they don't have the exact amount to go to Apple Store to purchase this identical phone, iPhone 13 Pro Max. So there are other alternatives, there are other stores, or they could purchase it online for a little price, a much cheaper price. Maybe now the price could be 1,000, and the individual intending to buy this new iPhone 13 Pro Max is getting it at 650. The actual price at Apple Store is 1,100 or 1,002, and there are other alternatives that you can purchase it online, maybe for the amount of 650 United States dollars. And you saw the package, everything, and you went to the store, you saw the phone, everything, you're looking nice. And you try it, but when you took it to your house, maybe for the following day, it couldn't come on. And you try to investigate, you took it to a technician, and when he opened it and you look at it, actually not an original iPhone. So there's a sense of deception there that have taken place. You have been deceived to think that you are purchasing an iPhone 13 Pro Max, but in actuality, it is something totally different from what you purchased. So that is misleading advertisement, and this is deception. Then we come to theft of trademark by changing a few elements to confuse what the consumers or end user of a given goods or service. So in the same example that I just used, confusing or changing few elements of a product or service to confuse the consumers. This can be particularly done with product like chocolates, maybe sneakers. The actual brand of the product maybe could be it was a NAC product with the NAC sign, but there are certain changes that are done on a sign to confuse the customer. There could be a specific brand or a specific trademark, but the 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 theft of the trademark is the sense where there was that individual or that business or company will make changes to smaller elements, maybe the trademark sign, the logo, or something will make certain changes that you as a consumer going to buy in a supermarket or in a store, you will not have the time to critically think to identify to say, oh, this is original NAC and this is duplicate, or this is a pirated goose, or this is original chocolate and this is duplicate, this is original Nestle, or this is the original Versace. Something might have been some elements of that actual trademark or brand might have been changed to confuse the consumer or the end user of that product. So that is what we refer to as theft of trademark. So antitrust deals with the dominance of cartels and ensuring that proper check marks and investigation are done when mergers and acquisitions are undertaken. So the reviews for mergers and acquisition must be very microscopic and intense to ensure that all issues related to anti-competitive practices are not executed. within mergers and acquisition. Unfair competition, we spoke about misleading advertising, deception, theft of trademark by changing few elements within a trademark or the brand to confuse the consumers or the end user of a given goods or product. So they are similar, but in general, they are two different subjects. In some countries, one agency is responsible for both antitrust and unfair competition. Um, in other countries, they might be under separate agencies. Uh, Other countries also could also adopt the approach where the antitrust is done by an independent agency, while the consumer protection is done by a ministry or government institution. So the institutional setting or the institutional framework varies across country. So BU might have a different approach or institutional framework for competition and antitrust. It could be combined, it could be separate, it could be antitrust on an independent agency, or competition is a government institution. So there are different approaches. There are varieties of institutional settings that are available for antitrust and competition law protection. So antitrust and unfair competition are what? Complementary. They complement each other. They are complementary concept. Antitrust and competition, antitrust and unfair competition are complementary concepts, so they complement each other. Consumer protection specifically addresses unfair competition. Consumer protection addresses unfair competition that is also targeted under competition law. Competition law addresses or deals with anti-competitive practices and unethical business behaviors, which is directly in favor of consumer protection. So consumer protection addresses unfair competition. So that's how it works. Um, Consumer competition law is intended to competition law is intended to address unethical practices by businesses or that have monopolistic characteristic. So in addressing anti-competitive practices, you are protecting consumers because consumers are the end user. They are the tail end of all these policies and implementation. Who benefits? The consumer benefits. So directly competition law is consumer protection, is for consumer protection. So to go further, I would like for us to move to another phase that speaks to the understanding between intellectual property and the interface between intellectual property and competition and antitrust law. So we want to look at the institutions or organizations engaged in uh, competition and antitrust protection. So we have for the first institution is UNTAC, is the United Nations Conference for Trade and Development. UNTAC. United Nations Conference for Trade and Development. So UNTAC has a competition law division, and they basically look at issues of um, anti-competitive behaviors. These member states of UNTAC I have issues relating to competition or antitrust protection, and within UNTAC, there's a competition law division to ensure that it addresses challenges uh, through policy development, through providing a space, a forum for this organization or institution to meet, to discuss, and to resolve challenges they are faced with. The World Trade Organization, the WTO, to also use to have competition work. It also used to work in competition and antitrust, but they were basically chewing more than they could swallow. They overstep. My understanding is they overstep what they wanted to achieve with the competition and antitrust initiative and program they were executing. So they got suspended in 2004 uh, because some of the reasons were because most of the WTO members country back then never had competition or antitrust policy or laws. They never had uh, competition law. They never had antitrust law. So going with the vision that you want to enforce uh, a competition protection and antitrust protection through a treaty could obviously be unacceptable for those countries that never had competition and antitrust law in existence back then, particularly for a country like China. China never had any competition antitrust law when this initiative or this program were in place to develop a treaty for for competition and antitrust enforcement. So the program in the UN team, I can say, was suspended or shut down for these reasons. Then we have the International Competition Network. So the International Competition Network was formed years ago. I might not be specific on the establishment date, or it's basically an informal network of competition, antitrust agencies, institutions engaged in uh, developing policies, developing framework, or advocating for consumers protection. So it's a network of it's an informal network with no secretariat to set up standards for enforcement whatsoever. It's an informal network where these competition and consumer protection and antitrust agencies meet to basically discuss issues that they are faced with in addressing competition and antitrust protection. And there are hundreds of agencies engaged that are members of the International Competition Network. And basically, they organize annual meetings where they all have a forum to discuss uh, critical issues affecting competition and antitrust. Then we'll come to the World Intellectual Property Organization, also that is engaged in IP competition, IP, intellectual property and competition protection. So the World Intellectual Property Organization has a division that is responsible for IP and competition law. And basically, this commitment derived from the development agenda. So the development agenda came to being when developing and emerging countries asked the World Trade Organization to form a long-term program to bring developing and emerging economies closer to the IP system. So within the development agenda, which is a long-term program that was intended to bring developing and emerging economy closer to the IP system, there were several recommendations for competition and antitrust enforcement or protection. And basically, it's the interface between IP and competition that is derived from the TRIPS agreement. There are provisions within the trade-related aspect of intellectual property rights agreement that has to do with competition and antitrust protection. So it basically look at how competition can be used to counterbalance the power of intellectual property. And again, this is derived from the misconception that intellectual property and competition are two concepts that are in clash. And on the contrary, intellectual property and competition law are complementary laws. They complement each other. So the division within WIPO that is responsible for IP and intellectual property was established to use competition policy to limit IP right protection and to implement the three recommendations of the development agenda that deals with competition and antitrust protection. The division is also responsible for collaboration among countries, member states, member of the uh, World Intellectual Property Organization, so they could collaborate on the gains they have made, the achievement they have made in uh, addressing competitions issue within their respective countries, the challenges they have faced, and basically a forum to share views, to exchange knowledge, and to have a general understanding on how to address issues related to competition and antitrust protection. The division is also responsible for providing technical assistance to various member states, but particularly developing and least developed country of low economies. So these are countries that face several challenges, including and, developing, crafting legislation, policy, and regulations with regards to competition, antitrust enforcement, consumer protection, and ensuring that if they succeed in developing these policies and laws and policy frameworks, that they can have the necessary technical know-how, the knowledge that is required, the trainings that are required to ensure that they can effectively implement uh, competition and competition, antitrust, and unfair competition and unfair competition practices. They also conduct studies. They conduct studies to ensure that maybe if a particular country was interested in a study to understand how how intellectual property and competition works, how antitrust can be productive, or maybe uh, just to have a general understanding on how the law have been applied in other countries and how they can use it uh, to contextualize that law within their country. So there are general studies with a view of ensuring that countries and member states, particularly developing and least developed countries, can have an understanding of how to implement competition and antitrust protection. And like I said, transition countries in transition and developing countries are the targets. They are the one mainly faced with the challenges of competition. For developed countries, the challenges, there are existing challenges, but they varies because these countries have engaged in engaged with larger firms for a longer time, so they have a greater understanding and they have the capacity, the technical know-how on how to address challenges of anti-competitive practices, of unethical business behaviors, because they have engaged in it for years and they have the financial, they have the technical as well as uh, uh, economic capacity to address it internally. But for developing and least developed countries, they are faced with the challenge. They have low technical know-how. They don't have the manpower. They might not have the resources required, and economically, they are innovation-wise, they don't have a innovative capacity to address issues uh, arising from competition and antitrust protection. So what they do not engage in is they do not engage in rule setting like treaties, because I think they have learned from uh, the mistake of the WTO program that was specifically targeted to address competition and antitrust issue, uh, trying to develop a treaty for enforcement when most of the WTO members were did not have laws, regulations, and policies for antitrust within a respective jurisdiction. So WIPO, IP, and Competition Division does not engage in rule setting or treaty development. They do not also engage in international harmonization. So they are not engaged in harmonizing rules, laws, and policy of competition because mm, the enforcement of competition and antitrust law is basically domestic, and and intellectual property protection in general is territorial in general it's territorial. So you have to enforce these laws uh, domestically within a specific nation or state. So WIPO IP and Competition Division does not engage in uh, it does not engage in rule setting or treaty development. It does not engage in international harmonization. So this is how we bring to end. Uh, this is how we bring to end this episode that deals with the interface between intellectual property and competition, as well as antitrust law. So a recap is that intellectual property protection is further enhanced intellectual property rights protection is further enhanced by having an effective and efficient competition law and antitrust law in place and that is enforceable. So competition law, like we said, just a recap, competition law is a body of legislation intended to prevent market distortion that is caused by anti-competitive practices. And in Canada, in the United States, and in the European Union, competition law is also known as antitrust law. So competition law ensures uh, the prevention of market distortion that is caused by anti-competitive business practices. While on the other hand, antitrust law is a law or regulation that encourage competition by limiting what market power of a particular firm. Antitrust law uh, encourages antitrust laws and regulation encourage competition by limiting the market power of any particular firm. They often involve ensuring uh, that that mergers and acquisitions are, are done in a way that market power is not overly concentrated to form monopolies. So market power must be equally distributed, that monopolies are not created. So within mergers and acquisitions, they cannot be done with the purpose of having it cannot be done with the intent of concentrating market share within a specific company. So the check and balances must be done by the government to ensure that this is not this is not the case where market share is concentrated um, within a specific monopolies. And antitrust law is intended to break up firms that have monopolistic characteristic. If you are a firm and you have a greater market share wherein you can make a determination on pricing for a specific goods within a market, the antitrust law is there to ensure that I break up those monopolistic firms so that competition can be restored and consumers can stand to benefit from lower prices, uh, a very productive consumer protection, and a very innovative space with new innovations coming that consumer can benefit from on a general. So basically, this is what we have to cover for now. We will have another episode, the second episode, where we'll be discussing some key studies from other countries and other issues relating to competition and antitrust protection within the US and in the EU, and actual cases that actual case study stuff we can read to have a broad understanding on how it works. So thank you for following. Thank you for your support. Thank you for always taking time out to follow us. We appreciate you. We asked, like we normally do, to continuously like, share, and comment. Please like, share, and comment. Your liking, your sharing, and your comments will increase the way the algorithm, the way our content is engaged with the algorithm, with the way this podcast is engaged in the algorithm. So more people can have a broad understanding on how intellectual property and international trade works. Thank you. Bye. 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 See you soon for on the next episode of IP competition antitrust law. Bye.